The other thing that you need to keep in mind when deciding on the 1107 is whether or not you might eventually want to pursue a 2254. The 2254 is the same kind of vehicle as an 1107, but it's to the federal courts for whatever jurisdiction you're in. There's a couple of problems with the 2254. First off is that it requires that you exhaust all of your claims in the highest criminal court in the state that you are in. So for Texas, that means you have to have had all of your claims heard by the Court of Criminal Appeals. Now, if you raised ineffective assistance all the way up on appeal and went to the Court of Criminal Appeals, you've exhausted those claims. You haven't added any evidence to it, but you've exhausted those claims and you can go straight into the 2254. Based on the way that appeals are handled in Texas, in that you cannot add evidence to the record, typically ineffective assistance is not going to be very advisable on direct appeal because you can't get counsel's response. So the favored way of dealing with it is through one of these Article 11 writs of habeas corpus applications. And so, those can take time to prepare, and this becomes a little bit problematic because the 2254 also has a hard deadline of 1 year from the date at which your conviction became final. And this can be problematic because 1 year may not necessarily be enough time to investigate and prepare an 1107. If you're proceeding under 1107-3 and you're dealing with a DNA issue, which has become one of the main issues in terms of recalculations on mixture DNA, there's this gigantic backlog with the state doing it. And the state will recalculate it for you for free, but they're going to do it on their time schedule, and they've still got to handle all the cases that are going and pending right now. So that can be problematic. You can pay for your own lab and get it done a little bit quicker, but again, you got to be able to afford to pay for that lab. So these can cause some problems in terms of getting to the 2254. If you have to choose between the two, your best bet is always going to be to spend more time on the 1107 and make sure you've got that done correctly. You have as much time as you need on the 1107, and so you can generally spend a lot more time on investigation, spend a lot more time on drafting, arguing, everything you need to do there that you're going to be hard pressed to do on the 2254. The other thing that you need to keep in mind is you cannot raise anything new in the 2254 than you could have in the 1107. Whatever you raised on 1107 or at the Court of Criminal Appeals, that's all you're going to get on the 2254. So if you miss something, because you rushed it on the 1107, well, it may very well be gone forever, because while you can file a subsequent writ of 1107, it's only based on newly discovered evidence that could not have been discovered prior to the original filing. This is meant to capture things like, in terms of prosecutorial misconduct, say the dirty cop lying on his deathbed finally fesses up to this and then promptly expires. Well, there was no way to know that he had been dirty and he had tampered with the evidence prior to that moment because he never told anyone else about it. So the Court of Criminal Appeals is not going to hold that against the defendant, and even if you filed an 1107, they will now let you file a new one, okay? But these are very rare instances. They're expecting you to do a full investigation, and anything that you should have known about that was readily available if you just looked for it and performed due diligence is not going to be available to you on a subsequent writ. So it's very important that you get that 1107 done correctly the first time, because the chances of you getting to file another one are going to be very rare. Absent, somebody fessing up to something on their deathbed or a very drastic change in the law, you are going to be stuck with that original 1107. A very informative case on this are the Robinson cases. Ex parte Robinson, there was 3 of them. And this is kind of what led to the existence of 1107-3. Robinson filed his first writ, I believe in the late 80s, early 90s. challenging his conviction on ineffective assistance grounds. That was unsuccessful. He then hired a new attorney later on. That attorney was able to do some digging and was able to speak with the original medical examiner in the case, came to the conclusion that the medical examination and the autopsy had been incorrect. And that writ was filed at that time, and while the Court of Criminal Appeals was very sympathetic, they flat out said there's nothing we can do about this because changes in forensic law are not accounted for. We don't have any precedent, we don't have any way of doing that. Well, luckily, the legislature was listening. They saw that. They wrote Article 11073, which allowed for attacking forensics and issues just like this. And so by Robinson 3, it was filed after 11073 and was the very first case to kind of explain how the process worked under the new statute. So, that's kind of how a subsequent writ is designed and contemplated as it coming in. It's going to have to be some changes, some things that really couldn't have been discovered earlier. As far as the process goes, they're all generally pretty much the same. You have an application that's propagated by the Court of Criminal Appeals. You will have to fill out that application. You need to fill it out correctly. Any errors will result in a dismissal for noncompliance, and you got to start the whole process all over again. And you won't know that it's dismissed until it gets to the Court of Criminal Appeals, which, as you'll see, takes some time, because under Article 11, you are required to file these with the district trial court in which you were convicted. The Court of Criminal Appeals is set up a lot like the United States Supreme Court. They don't have a witness stand. They are for oral argument and oral argument only, and they get a lot of these, so they typically essentially let the trial court handle the gathering of the evidence. So you're going to file that application. I feel that the best practice is to also file a brief, because once you file it, the trial court decides on how much of a hearing you get. They can do it by affidavit, they can do it by live testimony, but they're not really required to do one or the other. So the brief usually helps because it gives you a chance to kind of argue your case in full on the front end, just in case you don't get that hearing. Once it's filed with the trial court, it's then going to be sent over to the state. They have a certain amount of time to reply to it. If they don't reply to it, it just counts as a general denial, so don't think that you're going to get like a real quick, default judgment on it because they just didn't respond quickly enough. And then from there, it goes up to the Court of Criminal Appeals. They're going to have to kick it back if you raised anything like ineffective assistance of counsel and you did not submit an affidavit on the front end, and the state did not get a affidavit from trial counsel quickly enough. A lot of times these things get extended by what's known as an ODI, Order Designating Issues, which is contemplated in the Rules of Appellate Procedure. And that gives the trial court an additional 180 days to deal with the case, and they can ask the Court of Criminal Appeals for further extensions as needed. This is typically the way you want to handle it. It's going to give everybody plenty of time to get everything in, to make all their arguments, to make follow-up arguments, and to finally get a really nice set of findings of fact in front of the trial court. Now, the trial court has to gather this evidence, and they get to issue a recommendation. They do not have jurisdiction over the case, or at least not full jurisdiction. They will look at it and they will recommend to the Court of Criminal Appeals what they think should happen in the case. Court of Criminal Appeals is not bound by this, okay? They can reject it, they can follow it, they can kick it back down and say, we want further explanation on this, this, and this. Or, they can just go along with it. It really is up to them. But the final step is going to be those findings of fact. Now, if the findings of fact come down and you don't agree with them, you have 10 days from their receipt. That means you received a copy of them in which to file objections to those findings of fact. This could be a really good vehicle because you can point out any errors, anything that wasn't really resolved by the trial court's investigation, and hopefully show that whatever that recommendation is really not what it should be. From there, it goes up to the Court of Criminal Appeals, and again, as far as timelines go, the only thing you are going to get from the Court of Criminal Appeals quickly is the answer you don't want. I have seen cases pinned up at the Court of Criminal Appeals for multiple years while they kind of investigate. Maybe they kick some things back down, they argue about it. It can take a long time when you're up there. If they feel that you are procedurally barred, they will let you know that very quickly. So if there was a problem with that application, the district clerk doesn't have any authority to refuse it. It waits until it gets all the way to the Court of Criminal Appeals, and then some clerk's going to go through and say, oh, on page 5, you didn't check off box 5B or whatever it is. And therefore, it's non-compliant, and they're going to dismiss it, and you've got to refile the whole thing, which could be a very costly and time-consuming problem. So you want to make sure that that application is done correctly. If the Court of Criminal Appeals does not give you an answer that you want, you can go to that 2254 so long as you're within that 1-year deadline. Now, as far as that 1-year deadline, you do have one little thing that kind of helps you out, and it's a little bit of an exception, but essentially from the time your 1107 is filed until the time it is resolved, that time period does not count towards that 1-year deadline, okay? So what you want to do is you want to make sure that if it's possibly going to be available, you get that 1107 in as soon as you can. There have been multiple instances of 1107s being filed with maybe a couple of days left on that 1-year deadline. And that was because they wanted to make sure that a full investigation was done, and they wanted to make sure that they preserved that timeline, and unfortunately that's where it fell out. So sometimes you may have to kind of make a decision as to whether or not you want to start preparing a 2254 in advance, assuming that you're going to lose at the 1107, just to make sure that whatever time you have left is sufficient to get that 2254 in. It can be a very complicated process, and you really, really need an attorney for this, and you need one that knows what they're doing, because these timelines can be very hard and fast, and they can result in you waiving constitutional issues that would have potentially set you free. So you need to make sure that you've got competent representation in dealing with this process, because if the timelines lapse, you might have some problems. You do have a narrow exception on the 2254. It's the only time that you can raise ineffective assistance against habeas counsel is if they miscalculated that deadline on the 2254. The courts understand that this deadline is a little bit difficult to calculate because it depends on when your conviction became final, which changes depending on where you're at. For instance, if you entered a plea of guilty, your conviction became final for federal purposes 30 days after your sentence was entered, because during that 30 days you had time to file the notice of appeal. If you didn't, on the 31st day your conviction is final. If you go to the Court of Criminal Appeal or Court of Appeals, but not the Court of Criminal Appeals, it's still that same 30 days from the result of the Court of Appeals, because that's the time in which you have to file the PDR. It changes once you get to the Court of Criminal Appeals, because you actually have 90 days to file with the United States Supreme Court. So if you went all the way through a PDR, you actually have a total of 15 months, which can be put on pause by the filing of the 1107, in which to file the 2254. But you see how complicated this is already getting in terms of how much time it's taken me just to explain it. So again, I can't stress hard enough, you really need competent counsel when you're dealing with these things.